Good morning, Ms. Barlow. Can you hear me?
Okay, I can.
You're talking to the same audience in Fleetbank House as you were yesterday. Are you yourself on your own again?
I am at the moment, yeah.
And you're talking beyond these walls here to around 200 people who will be watching on a mixture of YouTube and Zoom, just as we were yesterday. But yet, unlike yesterday, we can actually start at 10. Yes.
Ms. Barlow, we looked yesterday at some of the Department of Health's records of the annual review meetings that you and Mr. Evans attended with the Department of Health in your capacity as Chief Executive of the Mcfarland Trust. Mm-hmm. And as I understand it, similar meetings were held in your capacity as Chief Executive of the Caxton Foundation. Why was it that the Mcfarland Trust or Caxton Foundation didn't maintain their own minutes or notes of the meetings?
I think it was just historical that because the department were the ones that, if you like, organised the meetings, they'd always been the ones that took the minutes. But as you saw from some other internal documents from MFT yesterday, that we reported back to the boards on what the discussions had been.
But there was no contemporaneous note taken by you or the chair of the respective trust of the meetings?
Not that were written up as minutes, no.
Would there have been your own notes or the chair's own notes, not produced as formal minutes, but maintained?
I can't remember at this stage.
Could we look at MACF 5024_002. This will be, I hope, the minutes of the first meeting of the Board of Trustees of the Mcfarland that you attended.
Mm-hmm.
If we go to page 6, that's the agenda. If we go to page 6, please, for the minutes. And we can see the date to the 21st of January 2013, and we can see if we go a little further down, we see there the board welcoming you and noting that you've taken up your post on the 3rd of January. If we then go go 3 pages further on, please, Shomek. We look under the heading Use of Reserves and Budget for 2013-14. We see there the chair advising the board that they were still awaiting a decision from the department, pressurising the department for an answer. That was in relation to reserves, which I asked you about yesterday. There's then the board considering recommendations from the Nssc about winter fuel payments. And we can see it being said that a winter fuel payment could not be afforded for non-infected widows, and then deferring a decision on discretionary top-up payments pending the Department of Health's allocation. And then if we go over the page, we can see, if we look at the first half of the page, you explaining the difficulties of setting a meaningful budget until the allocation for the following financial year was known. And then we see this. So following on from the discussion about various financial difficulties, we see RM, that's Mr. Mishcon, tabled a draft proposed letter to the Minister. This item had not been advised to the Chair or Chief Executive in advance. There was considerable discussion regarding the draft letter and the pros and cons of sending it at this stage. JB, that's you, expressed the view that to send a letter of the nature of the one tabled to the Minister in advance of any decision being made would not be constructive, and would also remove any room for further negotiation if an unfavourable answer was received. While several trustees were still in favour of sending the letter, others were either sure or against, and 2 trustees were also not present. RE, that's Mr. Evans, was not prepared to sign the letter. AB asked it to be recorded. He was unhappy with RE's decision not to sign. And then there's a proposal that the letter be forwarded to you, together with any amendments, for you and Mr. Evans to develop further with a view to sending to the Minister should we receive an unfavourable response. Now, I'm taking you to that to remind you of the context. I'm going to ask you to look at the letter now and then ask you some questions based upon it. So the letter, please, Shumik, is at WITN 4474004. Now this is a draft of the letter. Whether it went through a number of iterations, I'm not entirely clear, but it's the draft produced by Mr. Mishcon. And you'll see, if we just zoom in on the top half, we can say, we the undersigned, being all the trustees of the Mcfarland Trust, and then there's a couple of words missing, to express our concern and dismay at the prospect of having our annual allocation of funds further reduced. Then there's reference to the 2012-2013 allocation. And then the third paragraph, notwithstanding these annual payments to infected beneficiaries, many of our beneficiaries, including widows and dependents, remain in financial need. And in the current year, those needs have demanded that we will exceed the current year's allocation, even though we've declined more than half. And then there's a note to check the position in relation to office grants in value of requests for assistance. There's then a reference to a proposal from 2012 to utilise part of the reserves. And then if we go further down, and I'm not going to ask you further about that, I'll be asking Mr. Evans about that. Bottom of the page, the business case demonstrates the capital needs of our community of care far exceed the amount of our reserves, yet it appears our annual funding is likely to be further reduced in order that we're forced to utilise our reserves in making up the annual allocation. And then, yes, we would wish to draw your attention to the Charity Commission's publication and remind you that you and your department that we are solely funded by the department. Our duties as trustees are therefore being compromised. Then there is a reference to the position of the Caxton Foundation and a suggestion that account was not being taken by the Department of Health of the Mcfarland Trustees' beneficiaries' current health issues. Then there is a reference in the next paragraph to funding provided to the Thalidomide Trust, a commitment of £80 million over the next 10 years, and its reserves said to be in excess of £145 million. What justification is there for such a commitment when your department is seeking to reduce our relatively small allocation, pleading treasury constraints on the department and spending generally? We invite you as a matter of urgency to reconsider the commitment made by the government and take account of the matters raised in this letter. Now, that's the letter that was or a version of it, a draft of it, that was discussed in the minutes of the meeting that we've just looked at. You'd obviously only been at the Mcfarland Trust for a short period of time by then. Why was it your view that this letter should not be sent?
Well, I'm kind of glad to have the opportunity to answer a question on this, because the letter that was tabled on the day of the meeting, as I recall, concluded with a threat that all the trustees of the trust would resign if essentially they didn't get what they wanted. And it was that aspect of the letter that I felt was not helpful, because I think, as I said in one of my written statements, threatening to resign if you don't get what you want doesn't really leave you anywhere to go in terms of negotiating if the answer is different from what you want. So I hadn't been at the trust long enough to be able to comment in detail on the content that's there as you've read out today, but I did not feel that it was a particularly helpful approach for, in advance of hearing whether the department was going to grant additional funds, to actually, for the whole of the trustee board to threaten to resign. And so this letter that you are showing here today, I think must have been a subsequent draft.
Did you?
So I'd like to state that it wasn't, I was not objecting in any way to the Mcfarland Trust having its funds increased, but I thought, as a tactical move, threatening to resign en masse before an answer had even been received didn't leave the board any room for negotiation. And it was that I've said in my written statement, that was why I felt that it wasn't helpful.
Did you or Mr. Evans or indeed any of the other trustees who were unsure about the letter, proposed that it be sent but with the threat of resignation removed?
I can't recall how the discussion went, but after the meeting, essentially my recollection is that Mr. Evans took over, if you like, the discussion with board members about what should happen with this letter.
To your knowledge, was a letter in this form or this kind of form, minus the threat to resign, ever sent by the trust?
Not in this form, no. I don't recall that happening.
And the minutes themselves, we can go back to them if you want, but the minutes don't record the issue of resignation being the sticking point, do they?
No, they don't. They don't.
Who kept the minutes?
That is my absolute recollection of what happened, because I was somewhat shocked. You know, as I say, I think it was less than 3 weeks into my time at the Mcfarland Trust, and I'd never experienced a board member before tabling a letter of this kind. Certainly not without prior discussion with the chairman, and with such a threat included in it at the end. So I have to admit, but professionally, I was quite taken aback that such a letter should be tabled. And as I've said, I'm glad to have the opportunity to clarify that from my point of view, my reservations about the letter was about the fact that the trustee board, you know, if the letter had been sent out as it was, the trustee board was threatening to resign. But as I say, subsequently, Roger Evans took over, if you like, control of renegotiating or negotiating that letter with board members.
Can you assist us with why the minutes don't make any reference to the issue or sticking point being a suggested threat of joint resignation?
No, because I think that was my reservation. I think possibly other board members had reservations for other reasons, and as I've said in my written statements, you know, the chief executive doesn't have a vote at board meetings. You're asked to express opinions sometimes, and I gave mine in that regard, but I wasn't a voting member.
No, would you, again, we can go back and look at the minutes if you want, but would you accept that the minutes record you expressing some fairly firm advice to the board that the letter shouldn't be sent?
So at this juncture, I don't know why that wasn't recorded.
I want to ask you to look at an email Mr. Evans sent a few days after the meeting and ask for your views on a number of the points he makes. It's at WITN 1122029, please show Mick. We can pick it up at the bottom of the second page, please. Very bottom of the page. We can see Mr. Evans emailing on the 26th of January 2013, Dear Trustee, and then we go to the next page, please. It says, in case you're still wondering whether to send an individual trustee letter to DH, I want to clarify a few factual points with you before you decide. I note several trustees are not prepared to sign such a letter. I agree with their rationale for not being prepared to do so. And then he says this, several of you have asked me what influence DH has over the Mcfarland Trust. The answer is a lot. The government through DH set up MFT in the first place and could close us down at any time if they so wished. DH appoints 3 of our 9 trustees and they are our sole source of funding. The relationship is bound up in a trust deed and an amended version was agreed unanimously by our board a year ago. A DH-appointed trustee challenging DH in the proposed way would raise a number of questions within DH about loyalty, for instance. Do you have any observations about that paragraph I've just read and the observations about loyalty?
I guess it wouldn't be my view. I mean, as we discussed yesterday, the trusts were set up by the Secretary of State Department of Health, and they were solely funded by the department, but they were independent and as charity trustees, people had a responsibility to act in the best interests of the charity. So no one was, if you like, employed by the Department of Health, and as I take a different view as to whether loyalty was an appropriate way of thinking about it. As we discussed yesterday as well, there were some facts that you couldn't get away from, that as the sole funder, the Department of Health did exert some influence in terms of effectively limiting the work the trust could do to solely distribution of funds to beneficiaries because of the staff cap, and it inevitably led us down the route where there wasn't scope for doing much outside of that. But I still think we had the independence of thought to say things that the department might not have found palatable sometimes. As I said yesterday, our response to the 2016 Department of Health consultation document, I'm sure, was not met with great joy at the department, because it raised some real challenges to what they were proposing to do. So we were prepared to speak out. So I guess Mr. Evans and I perhaps had a different view on loyalty. And as I said before, my objections to that letter was that I felt that it would leave the Mcfarland Trust trustees nowhere to go if they threatened to resign if they didn't get what they want, and then they didn't get what they wanted.
Just picking up on your observation about the robustness of the AHO's response to the Department of Health's consultation, which is approximately 3 years, I think, on from the events that we're currently talking about. It might be said that the point in time at which the AHOs robustly took up a case against the Department of Health was the point in time at which their existence and the livelihoods of their staff were being placed in jeopardy, rather than at an earlier stage when it was the impact upon beneficiaries that was being placed in jeopardy. What would you say to that?
I would dispute that, because when the Department of Health consultation document was launched, there had been some discussion prior to that, which some of it came out of the APPG January 2015 report, about some kind of consolidation of the organisations. Because, as you know, there were 5 Alliance House organisations who together were all serving a subsection of the same overall beneficiary community. And within Alliance House, I think there was a recognition that, perhaps if you were starting from now, you wouldn't start and set up 5 separate organisations. So there'd already been some discussion about consolidation, which I think if you were to look at our response to the APPG report, the Mcfarland Trust and Caxton Foundation, as I recall, said that they wouldn't be opposed to merger as long as it was funded properly. And at the point at which we submitted that response to the DH consultation, we weren't aware that the department was thinking that the Alliance House organisations would no longer be the scheme administrator. So in that sense, that wasn't part of the thinking at that point. So our response was in no way because we were worried about our own future, as you suggested.
Just going back to the letter or the email on screen, you saw this at the time. Did it occur to you or did it concern you that the chair of the trust was suggesting that Department of Health appointed trustees had some kind of duty of loyalty to the Department of Health, and did you take any action to address that?
I can't remember whether we discussed that.
Do you, or would you accept that it would have been important to ensure that the Department of Health appointed trustees were not left under the mistaken view that they owed a duty of loyalty to the department?
Well, as I say, the chair and I obviously had a different view on that.
No, I understand that my question relates to whether you accept that you should have taken steps. I appreciate you can't remember, as I understand it, if you did or not, but do you accept you should have taken steps to ensure that the Department of Health appointed trustees at least understood that they were not under some kind of duty of loyalty to the Department of Health?
Well, it wasn't my role to manage the board. It was the chairman's role to manage the board. So I could not have gone behind his back to present a different picture.
Was it not your role as chief executive to advise the board about their role as independent trustees, their obligations under the trust deed, and if necessary, to seek legal advice if there was any doubt about that?
In conjunction with the chair.
And did you approach Mr. Evans and say to him, my view is you've got this wrong, we need to send a clear message to trustees that they're independent and must exercise their judgment independently?
As I've said, I don't recall.
If we go further down this email, we can see the next paragraph.
Just before you do that, what Mr. Evans says is the government could close us down at any time if they so wished.
Mm-hmm.
Do you accept that? Plainly, they could withdraw the funding.
Yeah.
But close you down?
No, legally they couldn't. Only essentially the board could make the decision to close the organisation down, but without funding, it kind of amounted to the same thing. And as you will have seen, when all this support was transferred to the NHS Business Services Authority, that's effectively what happened. And as we discussed yesterday, the organisations were essentially a vehicle for dispersing government funds. They were the sole funder, and once that funder wasn't there anymore, then the organisations effectively ceased to exist.
Well, it would have left a charitable trust with dwindling funds.
It would, but for a beneficiary community that was already being looked after, in essence, by another organisation.
Yes.
And the trust did actually run on for a period after the transfer to NHS BSA, and did actually run a final sort of big grants programme after November 2017 to use up those funds.
Yes. So technically, the expression is not one you agree with, though practically I think you're saying it comes to much the same thing.
Yes, I think legally it's incorrect, but practically it's correct.
Thank you.
We look then at the next paragraph. Mr. Evans says, so if we can just go up one line, Shomik, so I can see the whole paragraph, thank you. Must remind you again, a decision has not been made / announced. We continue to chase them vigorously and draw their attention to the repercussions of the long delay. And then this, as I said at the board meeting on Monday, I know the way central government works. And I suspect DH has already made a recommendation to the ministers on our funding and the reserves. This won't be an isolated decision, will be incorporated in a much bigger one of the entire healthcare spending programme. And then a reference to saying, I very much doubt, this is the last two sentences of the paragraph, that a letter from several individual trustees or from the board either will influence whatever recommendation they've made. What it will do is antagonise them and badly damage our future working with civil servants who are supportive of MFT. Two issues I want to ask you about in relation to that paragraph, Ms. Barlow. The first is the I know the way central government works observation that Mr. Evans makes in the third line and says he said that on Monday at the board meeting. To what extent were trustees' deliberations on matters such as this influenced by the view of Mr. Evans or indeed of other trustees that, oh, well, this is the way central government works and there's not much we can do about it?
I don't think it was influenced, but I think it was just a recognition that's of some knowledge of how it worked that fed into, if you like, the overall information about what was going on.
And then the view expressed by Mr. Evans at the end of the paragraph is that sending a letter from trustees or from the board would antagonise the Department of Health and badly damage the board's future or the trust's future working with civil servants who are supportive of the trust. Did you agree with that at the time?
Well, I think that kind of reflects the view that I had, that sending a letter which threatened, whether the whole board of trustees threatened to resign, was not the best sort of negotiating position to adopt. And I guess that's Mr. Evans' view on that.
If we leave aside the question of the threat to resign and think about what's said in the rest of the letter, the concerns that are there being expressed by Mr. Mishcon about inadequate funding, why would the sending of that kind of letter antagonise civil servants or badly damage future working?
Well, as I said, I don't think it's that. Well, I mean, I can't speak for Mr. Evans, but as I said, it was essentially the threat to resign if the trust didn't get what it wanted that I personally felt wasn't helpful.
So do you think
as I said, I hadn't been at the Mcfarland Trust long enough to have a detailed view on the rest of it, but given that the organisation did need additional funding, I don't recall having an objection to that per se. It was the threat to resign that I just didn't think would help the trust in its negotiations.
So you'd have had no objection to a letter in the form that we looked at being sent, which was minus the threat to resign?
Yeah, I mean, I can't remember whether there would have been detailed points at that time. As I say, I hadn't been there long enough, but my main reservation was about the threat to resign.
What, if any, experience did you have of the way in which central government worked or NHS funding decisions worked?
I hadn't worked for an organisation which was 100% funded by the Department of Health before.
And then if we look at the next paragraph, if we just look at the last sentence, Mr. Evans says, I'd be surprised if DH will be prepared to do so. That's have a dialogue. I'm sorry, it's the paragraph that begins in the future.
Yeah, I found it.
But I'm just going to look at the last sentence where he says, I'd be surprised if DH will be prepared to do so. That, I think, is have a dialogue involving trustees who are hostile to them. It might be said that the government, department, civil servants are used to, or should be used to, strong, robust, sometimes hostile views being expressed about their decision-making processes and their ultimate decisions. Did you share the concern that the department would somehow be unwilling to work with a trust board which included trustees who were, in some sense, hostile to the department?
I don't recall what my view about that was at the time, but as I said, I didn't feel that we couldn't, if you like, share unpleasant facts with the department if it was necessary. But having said that, I think, in general, one gets better results if one can work with constructive, if you like, collaboration and cooperation as opposed to hostility.
And then in the next paragraph, Mr. Evans says it would be very unwise for a group of individual trustees to pick a fight with DH and central government. And then he says this, you don't bite the hand that feeds you. Was that your understanding of Mr. Evans' approach to the department and to funding questions as a whole?
Well, as I said, I'd only been in the organisation for 3 weeks at the time, so I didn't really know much about his views at that point. But that's obviously how he felt about this particular issue at that time. But you'd need to ask him about his views on that.
I obviously, we'll do that. But you worked with him over the following 3 years or so. Was it your impression of his approach to the Department of Health that it was very much along the lines of don't rock the boat, don't bite the hand that feeds you?
No, not particularly, because we discussed yesterday, we did subsequently, continue to make the case and write business cases, which I'm sure the Department of Health didn't want to receive. So we didn't shy away from making it obvious or making it plain to the department that we needed more money and why we needed it. But again, I can't speak for Mr. Evans.
I want to go back to the first board meeting, but now on a different topic. So if we can go back, Shomik, to MACF 5024_002, please. And if we go to page 5, please, this document. Oh, next page. Sorry, Shomik. Sorry. And next one, my apologies. I think the page 7 electronically. So again, these are the minutes of the meeting on the 21st of January, so your first meeting as Chief Executive. And if we look at the heading Partnership Group, bottom half of the page, the last long paragraph, you'll see one key issue that's being raised here by the Partnership Group was the perceived breakdown of communications between the beneficiary community and the Trust Board, including confusion surrounding what financial assistance could now be asked for and what kind of things people could receive grants for, both through the office and the Nssc. There was a feeling from several of those who attended the PG, that's the Partnership Group, that the Trust should be there to help those affected, but at the moment it was not fulfilling this obligation. Overall, beneficiaries felt there was a lack of transparency and clarity from MFT, and also felt that the tone of some of the communications with beneficiaries was unhelpful. And then there's a reference to uncertainty over both benefit system changes and the issue of the use of the reserves. And then if we go to the next page, if we pick it up in the bottom half of the page, you'll see their reference to the National Support Services Committee. I'm not going to ask you about the detail of that. You'll see at the bottom of the page there's a discussion by the board of an appeal against a decision by the Nssc. And then if we go to the next page, we look at the second paragraph, so not the individual case, but the discussion that followed. There followed a discussion regarding the need for increased clarity, both in process and communication, regarding what can be applied for through the Nssc and what the definition of exceptional circumstances was relating to these. To ensure clarity going forward, JB, that's you, and RR, that I think was Ms. Riley, the Support Services Manager, would draft guidance regarding what could be applied for and submit it to the Nssc and board for consideration. The wider issue of trust beneficiary communication would be addressed via the broader work on communication. You would, I take it, have learnt from your attendance at this first meeting that there were real concerns about the lack of clarity, lack of transparency about both what could be applied for and how decisions were taken on applications. Is that right?
Yes.
And would you accept that it was important for the MFT and equally important for the Caxton Foundation that there should be clarity, transparency and fairness in the Trust's approaches to making payments?
Yes.
I'm going to ask you to look at a handful of documents in a moment, but can you tell us what actions you took following these matters being raised in January 2013 to address the lack of transparency and clarity?
I mean, ultimately, that was taken forward by the, if I can remember, it was, I think it was either end of 2014, around about that time, that we reformed the Nssc into a grants committee and published what grants were available and made that available on the website so that it was much clearer. And when the grants committee was formed, it did away with the this definition of exceptional circumstances, which Nssc had used.
The steps you're describing are, as I understand it, almost 2 years further on from this meeting.
Yeah, but it wasn't completely within my control because of the fact that it was the Nssc that made the decisions effectively on grants.
Can you recall whether, in advance of the steps you've described, whether, for example, there were any more urgent meetings with staff or with the Nssc to try and address some of these concerns about transparency and clarity whilst you were waiting for a more full-scale reorganisation of the process?
I don't recall.
We also have the reference here to the partnership group reporting that the tone of some of the communications with beneficiaries was unhelpful. Is that an issue that you took up with staff or committee members?
It was certainly an issue with staff, although, to be fair, I don't really think that a lot of the I think a lot of the staff communications weren't particularly problematic, but that was certainly something we looked at. And one of the issues that I found when I joined, I think we may have referred to it yesterday, was just the length of time that it took for applications to be approved. Sort of, in some cases, grants that went through Nssc were taking months and months and months to get approval, because the committee would ask for certain amounts of information, and when they got that, then they'd ask for additional information, and kind of, this could go on for a long time. And one of the things we did when we, if you like, as you called it, reformed the process, was to be really clear what people had to provide, so that once all that information had been provided to the committee, unless, there was some unusual circumstance, unusual reason why they would need anything extra, at the time at which the committee considered the application, then they had everything they needed to be able to make a decision at that point.
Can you recall whether any training was or advice was given to staff about the issue of tone and the way in which they should interact with beneficiaries, both orally and in writing?
Well, one of the things we touched on yesterday was the fact that during 2013 there was actually a restructuring of the staff team, and the person that was appointed had a lot of experience in a grant-making organisation and communicating with a wide range of beneficiaries, and I don't believe that the communications subsequently, certainly from the staff, were an issue. But people did have training, and we did look at the, if you like, template letters that we use to communicate decisions to trustees, to beneficiaries, etc.
We can take that down, thank you, Shemik. What information, as far as you can recall, in broad terms, I'm not asking you to recall individual cases, what information was given to an applicant typically in 2013 when you joined about the reasons for any refusal of an application?
I don't recall the detail of what was given to people, I'm afraid. All I can say is that when we, if you like, reformed the process, what we tried to do was be very explicit up front as to whether the thing that people were requesting was something that would be considered, so that people didn't waste their time making applications on things that the committee wouldn't be able to consider. And so we kind of, if you like, made the criteria quite clear and quite firm in that sense. And my recollection is that at the point at which Nssc was operating, it was kind of a little bit more open-ended.
Would you accept, as a matter of principle, that applicants whose applications were being rejected should be told the reason for that?
Yes, I think that's reasonable.
And if the reason was, at least in part, because the trust didn't have sufficient financial resources to give all the grants it might like to have done, would that be something you think should be explained to the unsuccessful applicant as well?
I mean, if that was the reason, and I just don't recall whether that was ever relayed. I can't recall at this juncture whether that was. I mean, my strongest memories of the committee process in Mcfarland were once the grants committee started operating.
Was it your understanding that the Mcfarland Trust was a provision of last resort, that applicants should seek assistance elsewhere and only come to the Trust if they've been unable to do so?
Not exactly, but I think one of the things that was, if you like, I'm not sure we could say it was a policy, but it was expected that, for example, if people were entitled to benefits, that they should apply for those benefits because that government funding was available to them. And if there were, we worked, if you like, in partnership with other organisations. So if people needed assistance with, I don't know, things to do like new boilers or something to do with, heating provision in the house, there were other charities that they could potentially apply to and get assistance with those things. Because if they could get money from those routes, it obviously left the Mcfarland Trust with additional funding, to help with other things where provision wasn't available elsewhere.
Although, would you accept that requiring, even with assistance, applicants to go down that route might, of course, lead to significant further delay before the applicant has whatever piece of equipment or respite assistance or financial assistance that they need?
I think it would depend, and I think we certainly, by the time the organisations had been operational for a number of years under my tenure, that was a process that was the team supported people with, and I'm not sure that huge delays were incurred there. And obviously, if it was an absolute emergency, then the committees would still look at it.
In terms of who took decisions on applications for assistance, please correct me if this is wrong. As I understand it, there were certain decisions that could be taken by the office staff. There were certain ones that had to be, either because of their nature or the amounts, referred to the Nssc, later Grants Committee.
Yeah.
And were there certain types of decision that could only be decided upon by the Board of Trustees?
No, I mean, it's sort of, if you like, in the normal course of events, then it was either the staff being able to approve things under the delegated authority of office guidelines or the Nssc / Grants Committee. And my recollection is that the only occasions where the board was involved in decisions about grants was when we ran the two big reserves grants programmes. So the one we talked about yesterday, which dispersed around sort of £820,000, and then the later exercise that we did in late 2017, early 2018.
Is it right, however, that grant applications might come before the board and be considered by them from time to time, either because the Nssc was unsure and referred the matter to the board, or because there was an appeal which was being considered by the board?
Certainly a second stage appeals might have gone to the board, and occasionally if there was a case where Nssc or Grants Committee was unsure, then they may have referred it to the board. I can't remember any particular examples, but yeah, that would have been something that could be done. But it wasn't, the normal course of events, if you like. It was normally either through office guidelines or through the committee.
How did the Trust, whether it's through the office or the Nssc, how did the Trust decide on the question of need, of whether that which was being applied for was something that the applicant needed?
Essentially, in relation to financial support, then the assessment of charitable need was essentially whether someone could afford themselves the item that they were processing or sending an application in for. So, for example, I mean, this probably wasn't a live example, but for example, if someone had a disposable income of £1,500 a month and they were asking for, I don't know, a £50 microwave, it was fair to assume that from a £1,500 disposable income that someone could afford a £50 microwave. However, if someone had a £200 disposable income and they needed assistance with, I don't know what it might be, mobility equipment or whatever it might be, it would be fair to assume that that person didn't have the resources to do that. But it was the Alliance House organisations at the point at which I joined were structured in such a way that you had the Skipton Fund and MFET who essentially made payments to individuals because they had been infected, and those payments were not needs assessed, when they weren't based on people's financial situation, and the charities were there to give additional financial assistance to those in greatest need. When it came to things like referrals to the money management advisor and the benefits advisor, those weren't needs assessed because they were essentially services that individuals required. And my recollection is that no one, if you like, inappropriately asked for access to those services, so there was no financial needs assessment done for access to those.
In terms of the financial need issue that you've identified, so that there would be consideration of what the disposable income was and whether it was reasonable to expect the applicant to purchase that themselves. What guidelines or criteria existed as to what might amount to disposable income, or how that should be approached?
Sorry, disposable income was the amount of money that people had left once their income and expenditure had been calculated.
How did those making decisions go about deciding if it was reasonable to expect someone to afford something? You've given what...
Oh, I see. As part of the application process, people submitted an income and expenditure statement.
Sorry, forgive me, my question's not clear enough. I appreciate you had, and I'll come on to ask you some questions about that, you asked for financial information. So you had financial information about expenditure and income and outgoings and so on. Equipped with that information, how would the member of the office staff or those sitting on the Nssc assess if it was something that it was reasonable to expect the individual to pay for themselves or not?
Well, I say it was a kind of a judgment based on the amount being asked for and someone's financial position and disposable income.
Was there anything by way of guidance as to how that judgment should be exercised?
Well, as I said, it was a judgment in relation to the amount being requested in relation to people's disposable incomes. I mean, it wasn't because it was always a different amount being requested in relation to a different individual's disposable income. You couldn't be absolute about it because every time the equation changed slightly. But in principle, it was, can someone afford this themselves? Because as we've discussed at length over the course of these days, the Trust had limited funding. So it had to target the resources that it had at those in greatest need.
Is this right, that there wasn't any form of, maybe because you didn't think it was necessary, but there wasn't, as a matter of fact, any form of written policy or guidance to decision makers about how to make that judgment?
No, not over what I've just described. And I say the reason for that, because it was almost impossible to give an absolute, because the equation changed every time for every individual and every request. The two sides of that equation would change slightly. So there was the whole thing of trustee discretion, which is, what charity trustees have. that came into play.
You've identified decision makers looking at the question of need from that financial perspective. Is this something that the individual can reasonably be expected to pay for themselves? What about the other aspect, or an other aspect of need, which is this something that because of their medical condition or their personal circumstances, the individual requires? So leave aside the question of what they could or couldn't afford to purchase for themselves. How were assessments of the underlying need of the individual for what was being sought undertaken?
Well, essentially, everyone who was applying for, certainly all the primary beneficiaries that were applying for grants were people who were infected with either HIV, and possibly hepatitis C as well. So we kind of understood, in the broadest sense, people's, if you like, their sort of clinical needs, in the sense that they were people who had been infected and who also had haemophilia. So that was kind of understood. But as I say, in a situation where you're providing financial support and you have limited resources, you have to have a way of being able to target those resources at the people in greatest need. And if you have someone who could afford something themselves and someone who couldn't, you clearly have to target the resources at the people who, without the Trust's help, wouldn't be able to get that piece of equipment or whatever it might be.
We've heard evidence and seen evidence that in earlier years, applicants were either required themselves to furnish, for example, supporting medical evidence from their clinician, or the Trust would write and ask the clinician for supporting medical evidence. Was that no longer the case then when you were working at the Trust?
Not for every application. I think if there were, I can't remember the detail of what grants people could have, but for example, if someone was asking for a respite break, for example, possibly after a course of treatment, then in that case we would have asked for a letter, sort of supporting letter, but we wouldn't have asked it for something that on the face of it wasn't anything to do with people's health status. So if they were asking for, I don't know, some kind of something to do with their home, for example, if they were asking for a new boiler, we wouldn't have asked for a clinician's letter to justify why they needed a new boiler. So it was only where it was relevant.
I want to ask you to look at a set of office guidelines briefly with me. It's MACF 40/171_058. Now, these are the 2011 office guidelines. There's then some grants guidelines which come in late 2014 or early 2015, which you referred to, which we'll look at in a moment. But were these or something like this the guidelines, the office guidelines in existence when you took up your post?
Yeah, I cannot. I mean, I was asked this question in one of my written statements, and I do not know what year issue the office guidelines were when I started, I'm afraid. I don't recall that now.
We can see it says apply before you buy. Was that effectively the policy against retrospective grants?
Yeah.
And if we just turn over the page, we can see there's a principle headed maxima. If a primary beneficiary has already had in excess of £3,000 in grants or more than 4 grants exceeding £3,000 over a period of a financial year, then the request will be presented to the Nssc. Why was that?
I mean, I don't know why that was introduced, and this is obviously a document dated 2011, which predates me by a couple of years.
Is it correct that the office guidelines that were in existence at the time you joined, and whether they were these 2011 ones or there was a 2012 version, I think that doesn't matter for the purposes of the question. These were not made available to, had not been provided to the beneficiary community, had they?
No, my understanding was that they hadn't been provided to the beneficiary community.
And if we look at MACF 40/149_042, we can see these are the minutes of a meeting of the Nssc 24th of April 2013. So this is after you've been there for 3 months or so, and you're in attendance. And if we look at the bottom of the page, under the heading Complaints, we can see, picking it up in the third line, the committee were aware of changes that beneficiaries were not pleased with, i.e. no longer publicising office guidelines. And then reference to an issue about school trips and uniforms. So is this correct that at some point, was it prior to your arrival, a decision had been taken not to publish the office guidelines?
Yeah, and I seem to recall something that this was actually something to do with the Archer, when Archer was published, the Archer report. So I don't think it was immediately before I started that they'd stopped publishing office guidelines. I think it was sometime previously, but I couldn't say when.
If we then go to MACF 40/171_042, please. You'll see here this document's entitled Grants Guidelines 2014/15, May 2014. So this is now obviously whilst you're Chief Executive. If we go over the page, we can see there the contents and the type of grants that are referred to in the guidelines. I'm not going to go to the detail of them. And then if we go to the next page, please, Shomik. You can see it says this under the heading Introduction. This document sets out the areas for which the Mcfarland Trust will consider making grant requests from 2014-15 onwards. It is intended for internal use only. It will not be distributed to beneficiaries. A summary of the key areas in which grants will and will not be considered will be produced separately as guidance for grant applicants. We'll look at the document that was for public consumption in a moment. But why was this document in 2014, and knowing everything you knew about the concerns as to lack of transparency and clarity, why was this document itself not to be distributed to beneficiaries?
I'd need to look at the whole document again, but essentially all the key points in terms of what could be applied for and what couldn't be applied for and how to apply, those were all made available. The information was on the website, for example.
Okay. Then we'll see the second paragraph says the document sets out criteria for which any such grants can be awarded under office guidelines by staff, the limits, the circumstances in which requests will be subject to consideration by the Grants Committee. It also highlights areas where requests will always be subject to consideration by the Grants Committee. And then this, in addition, it sets out what the Trust will not make grants for due to financial constraints. I think yesterday your recollection had been that grants were not rejected for financial reasons, but this would appear to suggest that there were grants that were effectively precluded from even being applied for financial reasons.
Yeah, but I guess that is two slightly different things. That in terms of the Trust decided which areas of grants it could offer, and then people were able to apply for under those criteria. And my recollection is that people weren't refused grants that fell under the criteria. But equally, the Trust couldn't have an open-ended grants programme where people could apply for absolutely anything because that wasn't affordable.
And then the last paragraph, falling under the criteria alone will not mean that a grant application will be automatically approved. The Grants Committee will give consideration to the individual circumstances surrounding each application on a case-by-case basis. However, the criteria provide a broad framework within which the committee will operate. If falling under the criteria alone wasn't sufficient, how did the grants committee take its decisions? Case-by-case basis doesn't really provide anything of universal application.
No, but I mean, that refers to things like what we were talking about before in relation to disposable income.
Was that not something also for the office guidelines, for the office staff to consider?
Sorry, was
the last
what?
Paragraph refers to the grants committee giving consideration to individual circumstances surrounding each application on a case-by-case basis.
Yeah.
And in answer to my question as to what that might mean, you've referred to the issue of the individual's own financial resources and whether it was reasonable to expect them to pay for it themselves.
Mm-hmm.
But this only talks about the grants committee doing that. Was that a judgment also made by office staff?
I guess to a certain extent it was. I don't really recall, but the things that were available under office guidelines, as I recall, weren't particularly extensive. But I think if someone had been applying, you know, as I used the example earlier, which probably wasn't a live example, but someone had £1,500 disposable income and was asking for a £50 microwave, then there probably would have been an issue flagged about that.
If we just go on to the second page, sorry, to the next page, just by way of example. I'm not going to take time up going through the detail of this. The inquiry has the full document, but you'll see by reference to the various items here, and it's the same throughout the document, that 2 quotes were required for each request. Why was there a requirement on beneficiaries who may themselves have been in significant ill health on many occasions to obtain 2 quotes for everything?
I think that was so that we could demonstrate, if you like, value for money, that we would, in most cases, approve the lower quote. Again, that was because of restricted funds and to try and ensure we had money to help as many people as possible.
Was consideration ever given by you or by the Nssc/Grants Committee or the board to the impact that universal requirement for 2 quotes might have on individuals?
My recollection is that there were very few examples where people weren't able to do this, but I do recall that on occasion, you know, the team would do whatever it could to assist people in the application process. But charities are required to demonstrate that they've assessed charitable need, and so we did require a certain amount of information. I mean, I think there were occasions, for example, if people were living in extremely remote areas and it just wasn't practical to get 2 quotes because there weren't enough, if you like, tradespeople in the area, then on occasion we would consider with just 1 quote, for example.
If we go,
but it was all about being what the charity needed to do to demonstrate that it was actually, if you like, operating in the way a charity was required to operate.
And if we go to page 9, please, Shomek. Just look at the types of support for which grants will not be awarded. This records the board has agreed a number of principles to guide how best it will apply its limited grant funding for the benefit of as many beneficiaries as possible. And then there are 2 principles set out. It will not act as a substitute for statutory funding or provision where this is available. Beneficiaries will need to demonstrate that they've exhausted statutory funding options in areas where these might be available. So what kind of evidence did beneficiaries have to come up with that they had exhausted statutory funding options?
I don't recall, but my recollection is that it was reasonably straightforward for people to claim hospital travel costs, and I recall the team giving guidance on how to go about that.
Were beneficiaries, for example, required to demonstrate that they'd made an approach to their local authority for consideration of provision of assistance under the local authority's community care powers, and that had been unsuccessful?
Yes, as I recall, and yeah, I recall seeing letters from local authorities that beneficiaries had received saying that the local authority either wasn't able to assist or was only able to assist up to a certain level.
And then
again, that, you know, this, if I may say, this we kind of talked about this a little bit before, but because the Mcfarland Trust funding was limited, it was very keen to try and ensure that the funding it used was targeted at people where, you know, they had the greatest need and where there were no other options, essentially. So if people could get support through mobility grants or through, as you say, local authorities for some adaptations to the home, then if beneficiaries were able to get it funded in that way, that meant that the Mcfarland Trust had more money to use for areas where that alternative funding wasn't available.
Do you recall whether the Trust ever sought any information or undertook any research as to how long, for example, local authorities might take to reach decisions on whether they would assist applicants for community care funding?
No, I don't recall doing any research on that, and I think we were just aware that it could vary from local authority area to local authority area. And as I've said previously, if it was an emergency and the process, say through a local authority, was going to take 9 months, then we would look at that case more urgently. I can't give you any specific examples, but that would have been how we would have approached it.
And then we can see the next principle is smaller household items which beneficiaries could reasonably be expected to fund through MFET and MFT regular payments and child supplements. So those were excluded, and examples given: household appliances, clothing, school uniforms. And then we see the Trust has therefore decided it will not make grants in the following areas. I'm not going to go through them all, but we can see the list of areas there set out. So is this right? From at least from May 2014 onwards, which is the date of this policy, grants for anything which fell within any of the listed items would simply be refused. Is that correct?
Yeah, the committee wouldn't look at applications under these headings.
If we go then to what I understand to be the published document, MACF 40171_049. We can see there it says from May 2014 the Mcfarland Trust is introducing new guidelines. Due to financial constraints, the Trust cannot consider funding some kind of requests. This document sets out the areas that can be considered as well as those areas for which funding will not be available. The document also explains how to apply for a grant. And then we see set out in very broad terms the grants that would be considered: accommodation-related, health-related, education-related, bereavement, with some examples given. And then what we cannot fund, and then we can see the areas listed that won't be funded. There's then a paragraph about retrospective items. Trust is unlikely to consider grant applications for retrospective items. We then have, under the heading, making an application, grant application form must be completed for a new grant request. As a charity, Trust is required to be able to demonstrate charitable need and as such consider whether someone applying for a grant has the ability to fund it from their own resources. This is why we ask for details of income and expenditure when grant requests are made. So is this right? Every time a grant application was made, the applicant had to provide details of income and expenditure on I think, a standard form?
That's correct. But if someone had made a relatively recent application and nothing had changed, we'd just use the information. If they confirmed that nothing had changed, we'd use the information that they'd sent previously without them having to fill all that detail in again.
Okay, and then if
the office staff would discuss with the applicants.
If we go to the top of the next page, we can see there's a reference then to supporting evidence, for example, medical letters required for some grants, and its suggested details listed on the application form. Then we have the reference to the requirement for 2 quotes. Processing grants, it's explained some can be done by office staff, some will go to the grants committee, which meets every 6 weeks. And then we have a small heading on advice on benefits and money management debts, then reference to appeals, which was, as I understand it, to the grants committee if there's new evidence, and if there was no new evidence but it was a complaint about the original decision, it would go to the full board. Is that right?
No, the appeals process was a 2-stage decision, and for appeals to be considered, people had to provide new or additional information. And the first stage was it went to the grants committee, and then if people were still unhappy with the outcome, it could be the second stage was that it went onto the board.
Would you accept that's not necessarily entirely clear from what's set out here, which would suggest you didn't have to have new evidence, the last sentence?
Possibly.
And then the last 2 bits are returning the application form and further questions. Now, there's nothing in this document, as far as I can see, which sets out that principle we looked at in the internal guidelines of not acting as a substitute for statutory funding and of beneficiaries needing to demonstrate they've exhausted statutory funding options. Why is that not in the published material?
I don't know. It's probably I can't do that. It was probably an omission as opposed to. I mean that was something that was very kind of, if you like, something that was talked about with applicants.
And then
so it wasn't a secret, if you like.
And then if we just go back to the internal document, MACF 40171_042. And if we go, for example, to page 8, this is just again by way of example, we can see that there are maximums here given, figures for the different types of items. So these internal guidelines spell out specific items and give a maximum and the number of times something might be considered. So you might be able to apply for something every 10 years, something every 5 years, and so on.
Yeah.
That information is not part of the published material. Why?
No, because this was office guidelines.
But why should... Sorry, carry on.
This information was the grants that could be approved by staff under office guidelines within those, if you like, financial maximums and the time limits where they existed. If someone... if you like, if someone had applied for, I don't know, a bereavement grant that was more than 3,500, even though that was the office guidelines limit, that would still have been able to be considered by the committee. So we didn't want to put people off by, if you like, almost misleading them with the information that was in office guidelines, because people could still, those applications could still be approved or looked at by the committee, but this was, if you like, the delegated authority for staff.
But why not simply spell that out to beneficiaries? So you could have devised a publication which says, up to a maximum of 3,500, funeral plans or bereavement grant applications can be considered by office staff, which will be quicker, presumably, because the office staff are there in the office every day as opposed to meeting every 6 weeks. An application in excess of that will require to be considered by the grants committee, and then beneficiaries will be in a position of knowing how their application was going to be considered and by whom, and perhaps having the choice to elect for something that they knew could be determined more speedily.
Well, I think the reality was that pretty much on most occasions when people were making applications, they actually had a discussion with a member of staff about what it is they were wanting to apply for. and the member of staff would advise as to whether that would be something that they would be able to consider under office guidelines or whether it was something that would go to the committee.
Why not just then publish that so all potential applicants could be aware of that?
Yeah, I can't recall, over and above what I've said as to why that wasn't done.
Can you identify any good reason why it wasn't done?
Well, as I said, it was so as not to mislead in terms of the office guidelines were that there were guidelines that staff could use to approve grants so that people didn't have to wait for the 6 weekly committee meetings. But it didn't mean that if it couldn't be approved under office guidelines, it couldn't get approved by the committee.
In what circumstances was it effectively a requirement that the applicant agree to see a money management advisor?
So did you say when was it a requirement?
Yes, or in what circumstances was it a requirement that in order to receive assistance they have to see a money management advisor?
Well, sometimes people actually proactively asked for a referral to a money management advisor. So that was actually a service that people sought out. But in other circumstances, it would relate to issues like debt. So if people were asking for support with problems with debt, then a referral to the money management advisor would be recommended. And that was on the basis that the money manager, our experience was that, many times the money management advisors were able to do things like negotiate debt down, or have people's repayment options altered, and those were all things that they had the skill and expertise to do, which we didn't. And so essentially, by the time someone might come to us with a debt of £30,000, and by the time the debt advisor had been through the process with them, negotiated with the creditors, that might be down to maybe £5,000 or £10,000. Now, clearly, with that input, we could potentially help 3 to 6 people who initially came to us with a debt of £30,000 instead of just one person, because of the input that the money management advisors could have.
Were there cases in which it was effectively a precondition of receiving assistance from the trust that the applicant see the money management advisor?
I think quite often it was, because it helped the trustees to understand what the overall situation was. And I said, one of the major advantages was that Penny Smart was quite often able to reduce debt down, and they had the expertise to do things like that, which the trust didn't have.
Were you aware of it being an issue or a concern for some people that the involvement of the money management advisor might require people who kept their HIV status private for many years, to divulge it to a third party?
Yeah, we were aware that very occasionally that was an issue. But actually, in many ways, because Penny Smart, who were the money management advisors, because they were independent of the trust, when they were, if you like, negotiating and having discussions with creditors on the beneficiaries' behalf, because they were an independent agency, that link back to Mcfarland and Caxton as well, that wasn't there, because they were an independent organisation negotiating on behalf of those individuals. Whereas if we'd done it and been saying directly, we're the Mcfarland Trust, then that link between the beneficiary and what the trust did would have been more obvious.
One final question, if I may, before we break, and it relates to the concept of exceptional circumstances. If we go to MACF 40149_028. And if we go to the last page, please. you'll see there, this is a response from Keisha Hanshard, Support Services Officer, to a beneficiary who posed questions about exceptional circumstances. And this was the answer from the Nssc that she relayed. There's one criterion for Nssc grant applications: beneficiaries must show exceptional circumstances. And then the definition is: exceptional circumstances are circumstances that have arisen or are threatened, which in the opinion of the Nssc/Board of Trustees are unlikely to have been anticipated by a beneficiary in the ordinary course of events, and or it is unreasonable to expect a beneficiary to have to deal with the financial outcome from their normal expenses. Another way of putting it is that these grants are not meant to be for standard household occasional needs, e.g. a washing machine. Two, following from the statement above and assuming there is no exceptional circumstance, there's no way of presenting an application for a washing machine that would qualify for a grant. Three, anything that would be expected to be covered by the non-discretionary payment, normal household expenditure, would not be entertained, that is, would not be eligible for a grant. And then four, neither, that's an answer to the question that one sees at the very top of the page.
Which I can't see.
I know, if we just go back to the whole document. The question at the top of the page was, does the Nssc have a secret set of guidelines they do not want the PBs, its primary beneficiaries, to know about, or are they just winging it as they go along? Answer, neither. The criterion is very clearly explained and available to everyone. Trustees are committed to distributing this small amount of money in the fairest way possible, meeting the costs brought on by exceptional and unforeseen need. Now, just a handful of questions arising out of this. Was this exceptional circumstances sole criterion for Nssc grant applications, the criterion in existence when you became chief executive?
It was.
And
when's this document from? Is it?
This, these are emails from August 2013.
August 13.
So, as far as you can recall, exceptional circumstances was the criterion used when you arrived?
Yes.
And do I understand your evidence earlier that when the Nssc was reformed into the Grants Committee, and we've looked at the May 2014 grant guidelines, the criterion of exceptional circumstances was removed?
It was.
So for the first year and a half or so that you were there, but predating your arrival, this was the criterion. Looking at what's said to be the definition of exceptional circumstances in paragraph 1, do you consider that to be a straightforward or easy criterion to understand and apply?
No, I would say not. And one of the reasons we subsequently moved away from that was that, we realised that, beneficiaries really struggled to understand what that meant in terms of what they could apply for. I mean, you can see, the definition goes on for several lines. And, whether people think we succeeded or not, we did move away from that and try to be much clearer about what people could and couldn't apply for.
Thank you. So I note the time. Perhaps a convenient time for a break?
Yes, just one question arising out of what you were saying this morning. You were asked at the very start about the board meeting on the 21st of January 2013. And you were asked about a report subsequently received, which spoke about what had happened at the end of the year before, when a number of complaints had been made about the communications from the staff. You answered counsel by saying a lot of the communications weren't particularly problematic, and then you went on.
Mm-hmm.
The use of that expression means that some were particularly problematic. Can you give me an idea of the sort of communications that you did find particularly problematic, and secondly, tell me what you did about it?
In my view, one of the areas that was particularly problematic was in relation to some of the delays that we've discussed in relation to grants, where it could take many months for people to get a response to their grant applications, and that was what ultimately we were trying to address when we moved to the grants committee and the more explicit criteria.
So just delays.
In my view, that was one of the biggest issues.
Well, what were the other?
Length of, sorry.
What were the other issues?
I can't recall, but that, as I say, that is the main issue, as I recall, that there was this issue about the grants taking such an awfully long time to be processed in some cases, and then the communication backwards and forwards with beneficiaries being quite difficult because the whole time people were being asked for more information.
I see. Well, we'll take a break till 10 to 12. 10 to 12.